Hello, everyone, and welcome to this session on drafting a basic service agreement, clauses that every lawyer must know. Now, if you're a law student or a young professional, understanding how to draft a service agreement is not just an academic skill, it is also a core professional competency. In practice, a large portion of your work will involve drafting agreements for clients, and a service agreement is often the starting point. Now, today we will break down this in a structured and a practical manner with reference to the Indian laws, especially the Indian Contract Act. Now, before we proceed, let's begin with the basics. A service agreement is a legally binding contract between a service provider and a client where one party it agrees to provide certain agreements, certain services in exchange for consideration. For any agreement to be valid under the Indian Contract Act, it must satisfy the essential elements such as an offer, acceptance, lawful consideration, free consent, capacity, and lawful object. Now, if any of these elements are missing, your agreement may become void or unenforceable. Now, let's move to the structure of a service agreement. A well drafted service agreement is not about using complex language, it is about clarity, precision, and risk allocation. We will go now clause by clause. First, the title and the introduction clause. Now, this is where you will clearly state that the document is a service agreement along with its date and place of execution. You must then identify the parties properly. To identify the parties, always include their full legal name, address, and legal status, whether they are an individual, company, LLP, or partnership. If it's a company, ensure compliance with Companies Act 2013 by mentioning the SIN and registered office. Now, the second clause is your definitions clause. This is one of the most underrated clauses that you have. For example, terms like service, confidential information, effective date, deliverables should be clearly defined. Always avoid vague definitions because ambiguity is something that often leads to dispute. Third is the scope of services. Now, this is the heart of the agreement. You must clearly specify what services are being provided, the manner of delivery, the timelines, and the expected outcomes. If the scope is unclear, the agreement becomes very difficult to enforce. Always draft this clause in a detailed yet structured manner. Fourth, term and termination clause. You must specify when the agreement begins, what is its duration, and the conditions under which it can be terminated. Include both termination for convenience and termination for breach. Also include the notice period. A poorly drafted termination clause can expose your client to unnecessary liability. Fifth, consideration and payment terms. Under the Contract Act, consideration is essential. So clearly mention the total fees, payment schedule, mode of payment, and applicable taxes like GST and TDS. Along with this, you also need to include what are the late payment penalties and consequences of non-payment. Never use vague phrases like reasonable payment. Sixth is the obligation of parties. Clearly define the responsibility of both the parties. For example, what the service provider must deliver, what support the client needs to provide. This ensures accountability and reduces disputes. Seventh, confidentiality clause. Now, this is very critical, especially in professional and corporate engagements. Define what constitutes a confidential information. Specify obligations of confidentiality, duration of obligation, and exceptions. You may also align this with principles under the Information Technology Act, especially in digital transactions. Eighth, intellectual property rights clause. This is extremely important in media, consulting, and creative services. Clearly specify who owns the intellectual property created, whether the rights are assigned or licensed. Refer to the Copyright Act 1957 when you're dealing with creative works. Ambiguity in this clause quite often leads to major disputes. The ninth, indemnity clause. Now, this clause protects your client from losses arising due to other parties' action. Clearly define scope of indemnity, extent of liability, and conditions under which indemnity applies. Be precise, overbroad clauses can also be challenged. 10th, limitation of the liability. Now, this clause limits financial exposure. You may cap liability to a specific amount or to the contract value. However, ensure the limitation is reasonable and enforceable. 11, your force majeure clause. Now, this clause deals with unforeseen events like natural disasters, pandemic, or war. Clearly define what events qualify as a force majeure. Specify the consequences, whether it is a suspension or termination of contract. 12th, dispute resolution. You may provide for negotiation, mediation, arbitration, etc. If arbitration is chosen, ensure compliance with the Arbitration and Conciliation Act of 1996. Also specify seat of arbitration, number of arbitrators, and governing law. 13th, governing law and jurisdiction. Clearly mention that the agreement is governed by Indian law. Also specify that the courts which will have the jurisdiction. Now, this avoids unnecessary litigation confusion. 14th, boilerplate clauses. These include the entire agreement clause, your amendment clause, waiver clause, severability clause, and notice clause. They may be, they may look very standard, but they play a crucial role in interpretation. Now, let's discuss some very practical drafting tips. Always write in simple and clear language. Try to avoid unnecessary legal jargon. There's a huge misunderstanding amongst lawyers and law students that the more complicated language you use, the more lengthy document you make is a strong agreement. A strong agreement is always crisp, to the point, and it covers the needs of both the parties. If the agreement is not customized, it's never a good agreement. Ensure consistency in terminology. You also need to cross-check all clauses for contradiction. Proofread thoroughly, one thing I don't need to tell you. And most importantly, draft with a mindset of anticipating disputes. Don't think that your job is only to create an agreement. You need to create an agreement because you are trying to avoid any future disputes. Okay. A good drafter is someone who foresees the risk and then addresses them in the agreement itself. So basically, to conclude this session, drafting a service agreement is not just about putting clauses together. It's also about understanding the transaction, protecting your client's interest, and ensuring enforceability under the Indian law. If you master this skill very early in your career, it will give you a very significant professional advantage. Thank you for joining this session. If you found this session useful, do share it with your fellow law students and professionals. Thank you so much, and do join me in the next upcoming session, which I will begin in the next 2 minutes.